Thanks everybody for joining. It's been great to meet a handful of you. I think this is a super invaluable network for us as well, because just of the folks that I've met or heard themselves being introduced, I just hear value to a lot of our clients. I think as you may know from Roger, we're an international law firm with over 700 attorneys spanning the US, China, Mexico, and London. And our clients have needs, and some of them we can provide on the legal side, but lots of them we can't. And so we can become a very trusted advisor to our folks by introducing them to people like you all. So I hope to connect with more of you throughout this presentation and after. The purpose of today's discussion is to run through, I think, some of the highlights of this American Bar Association deal point summary. As I noted a minute ago, I think this is a really nice thing that, number one, you all have. I think most of us lawyers have to pay for this. So the fact that Roger circulated that you all now have is value add in and of itself, a reason for joining. But I use it sometimes as a sanity check on transactions that we're working on that we may not see day in and day out in terms of certain specific deal points. But overall, it's just a good guide to try to predict where the market is going. One thing I'll note is that this is current as of Q1 of 2023. So as we all know in the deal world, the goalposts move quarter over quarter and year over year. So we're already about a year out from when this data has been memorialized. And so as part of this discussion today, I will try to voice over where the market has moved from these data points. But instead of going through every slide and going through everything in minutia, which I think you guys can do on your own time, I want to stop on four key topics throughout this talk. Those are financial provisions, the reps and warranties that we see companies making, we see buyers kind of using to protect their transaction. Number three, certainty and conditions to closing once you have a deal signed up, how to get that deal actually closed, whether you're a buyer or seller, or I'll tell you a secret, if you're on the buy side and you don't want that deal to close, how to get out of it. And then indemnification, ways parties in this marketplace are using or tools that they're using to protect themselves as part of entering into a significant transaction. Before we get into those four topics, I think it's important just to do a general overview of where I see the market. As Roger noted, I specialize both in private and public M&A for strategic and financial sponsors. I think largely their interests overlap, but I think financial sponsors have a very different being and why they're doing transactions as opposed to the strategic sponsors. And so at Haynes Boone, we don't specialize per se in financial or strategic. We handle kind of M&A of certain sizes. One thing to note as slide number 6 here on the screen shows is that the lower middle market is still king, right? We're seeing 62% of transactions in the sample size here, sub 200 million. The large deals are running into more and more complexity, especially with what we think is a DOJ that is very active and very targeted. So antitrust risk, even over 250, is becoming more of our concern as we're talking to clients that historically was only reserved for the true mega transactions. That is something that we're starting to brainstorm and discuss with clients much more often. So as such, these deals that are the lower middle market, I think specifically sub 100 million, are carrying much of the deal volume that we're seeing through 2023 and certainly into 2024. I think this is slightly inaccurate. I think there's if you take the bring down from 2023 to current, we're seeing even more transactions sub 150. So I think what the data on the screen is showing at 62%, I still think we're seeing even more in this lower middle market range. Raj, if you click the next slide. Where the deals are happening, this has historically been fairly constant. If you look on the top left, the top 3 industries we're still seeing a lot of activity is in technology, healthcare, and financial services. I think if you look at Haynes Boone as a firm, almost 45% of our transactions are in one of those 3 buckets. I think those are largely, you can fit a lot into that. It may be a software deal, it may be a pure tech deal, but I think technology year over year still is one of the dominant players as far as industry M&A goes. I think looking at 2024 and beyond, we're seeing infrastructure, aerospace, and defense and government contract deals on the rise. For those of you paying attention over the weekend, the government passed another spending act. Whether we have the money to actually fulfill that is another question. Tax day was last week, so I think they're going to be flush with some cash. But the government is not slowing its spending down. And as such, I think private equity and strategic sponsors are focused on getting into those areas, if they're not already, through M&A. So we're already seeing an uptick in the infrastructure, aerospace, and defense deals, largely following where the government's going in its spending. Otherwise, I think my 30,000-foot view on the marketplace is I was very optimistic heading into this year. We saw a nice uptick in December, October to December, so Q4 of 2023. But I think our expectations are resetting as we get into this year. Most of our clients that we're talking to are trying to sell core assets that are their best and brightest this year. But in terms of a general market excitement, that now is being pushed off to Q1 of 2025. Interest rates have a large reason to do with that. But what used to be very exciting this year, and I think we were very optimistic, we're starting to see the reality of this current deal-making environment really come through in the number of transactions that are actually coming to market, and even worse, the valuation gaps that we're still seeing as buyers are looking to pay only what the companies are worth, and sellers are still holding on to kind of valuations that were years out. So going into the first section, Roger, if you could move to page 10 of this. This is in the financial provision. So in a transaction, we see this as being one of the main buckets of valuation creep, I will call it, in a deal. This includes purchase price adjustments, working capital, kind of the general financial piece of the health of the business. And we see so many times in these deals where companies do not work with the right accounting firms. This is a nice intersection between legal, writing what the parties kind of have agreed to and what is currently reflected in the business, to what is actually happening in the business from an accounting perspective. And we see this as a sophisticated buyer's way to an inherent purchase price adjustment or a discount in the transaction. Oftentimes, one of the parties is much more sophisticated as to the working capital and the current assets and current liabilities of the business. More often than not, that's oftentimes the buyer. A lot of people think that the sellers who know the business, who have a beat on working capital, are the ones that know that better. Sometimes that is the case, but a lot of times buyers who are paying substantial amounts of money and multiples on businesses will hire folks to come in and reverse engineer these businesses better than the sellers themselves know. And so a lot of emphasis is placed on these post-closing purchase price adjustments. In layman's terms, this is working capital, right? A business is contracted to deliver a target level of working capital. I view that as enough gas in the car to get off the lot and start driving as you expected. Sometimes it's a full tank of gas, but it's never an empty tank. Well, I should never say never. Sometimes negative working capital is part of a transaction. I always think of working capital as something that should not be something that either party makes money on. You agree on a threshold, you set the appropriate rules to correspond with that threshold, and then you true up after the dust settles. In reality, sophisticated buyers and sellers, I will say, are using these purchase price adjustments as ways to move consideration. If you think about what I said a minute ago in terms of valuation gaps, you can sometimes see an upwards of 5 to 10% swing in working capital, but overall in the purchase price if these are not done or addressed properly. And so how can parties properly address working capital and minimize these disputes? Number one, as a seller, we always recommend a sell-side QV. I know that costs additional money. There are a lot of firms that can do that for a very valuable, for a very, a fraction of the cost of some of the major accounting firms. but that helps understand the business down to a level that the buyer is going to use. The buyer usually uses to rely on in setting its price. The second thing is look at your accounting definitions in these transactions. And Roger, if you can flip to the next page, you can see there are all these specified terms in here that correspond with things like indebtedness, things like cash, things like working capital. What is working capital to one business is not to another business. And so often I see these businesses misdefine these terms using form legal terms that otherwise create problems down the line. The third thing I think also is most important is know your sample calculation. If you're going to provide a working capital target, it's always great, in my opinion, to have a sample calculation on the back that gets you to that number. If we're going to show a number in the contract of 3, you show an exhibit of 1 + 1 + 1 = 3, thus setting the rules of construction of how you got to the 3. Again, the point of this is to minimize post-closing true-ups or adjustments, which buyers and sellers, I will say the sophisticated buyers and sellers, are using to their advantage to offset purchase price. Roger, if you can flip ahead to slide 14. One of the points that we see a lot of is escrows, right? So in a transaction, the parties will set a target working capital and then have if that number's over, they'll get money back. If it's under, they'll give money back. One of the ways that on the sell side, we try to protect our clients is to say, okay, let's set up an escrow that will serve as your sole source of recovery to a seller that gives you comfort that once the transaction's happened, there's nothing else that comes back to you and your liabilities within the 4 corners of the agreement. The buyer, on the other hand, does not want that and wants to say, look, if the number is off dollar for dollar, if it exceeds the escrow, we want to come after you directly. 60%, if you look on this slide, 60%, I'm sorry, 16, Roger, 2 more pages. 60% of transactions now are, 60 on the bottom in the green. 60% of transactions, the sole source of recovery is not an escrow. The thing to focus on is 40% is the sole source of recovery. That number has come up substantially in the 20 years that I've been doing this because buyers are looking to provide sellers certainty to closing. And in a competitive landscape where there are multiple bidders, coming in and limiting recourse to an escrow is very attractive for a seller, something that we always push for on the sell side, given the construct that I just alluded to, that oftentimes buyers and their sophisticated financial advisors and accountants and lawyers know that target business better than anybody. And so if they're comfortable with the potential fluctuations in here, then we can understand exactly what it is we're dealing with and get comfortable with an escrow being the sole source of recovery. One other point in the financial provisions, Roger, if you can go to page 18, is earnouts. Earnouts are something we always track as a firm because that to us signals a departure in a valuation gap. Cash is always king. Cash or stock is king. And so if a valuation is 100% and you think your business is worth 100, whether that's $1 billion or 100, whatever that number is, and someone comes in at 80, there's a 20% valuation gap. And so companies historically, buyers and sellers historically, have helped bridge that gap with earnouts. If these things are hit, then I will pay you 100. In my experience, I can count more times than not where the earnout has failed for various reasons. And I can count on one hand the amount of times that a buyer has gladly, with joy, paid the full earnout. Again, we look at these earnout trends largely to see valuations, right? Because in a healthy market where companies are asking for valuation thresholds and receiving those valuation thresholds at or near where they're asking, we do not see any earnouts. However, when the valuation gaps are present, which we've seen over the last couple of years, the earnouts come in to help preserve that upside of valuation. I think this is, as you can see here from the mark from 2021 to 2023, so in that very short window, The earnouts, as reported, are up 20%, from 20% to 26%. So they are on the rise. And I think from a Haynes Boone perspective, across all of our firms, we track this own data ourselves, we can validate that they are in fact on the rise. In terms of what earnouts are largely driven by, you can cut that however you want, but largely we see it driven by the revenue of the business. The downside with earnouts, of course, is that you're no longer driving the bus. And so if I'm a founder or an owner of a business, I'm very comfortable about getting to my destination if I have control and I'm driving that bus and I can get there on my terms. No buyer really is going to ever deploy that capital and allow the former seller to drive that bus however he or she sees fit. And so you see issues, which you'll see in the study here in detail, about what types of covenants, what type of parameters are in place. And largely on the sell side, the best that you can ultimately expect to receive are parameters around taking action, the sole purpose of which is to destroy the earnout, which I think nobody's really going to do. And that's something largely you can avoid if challenged. But rarely do we see buyers providing that certainty in the form of an ongoing covenant to a seller about running the business how it sees fit to maximize the earnouts. I saw a comment from Naomi here. I agree with that for sure. And I think for those of you who don't see that chat, if the earnings are tied, if the earnouts are tied to earnings, revenues, or stock, private company stock price, makes the valuation surrounding post-close very complex. Yes. Most items within an earnout are complex, and because it's one of those things that rarely is certain, right? No one ever says I'm going to run a 20-minute mile and then runs a world record, right? In those instances, everything gets paid out. Every other instance is somewhat gray. And so as a seller, you have to expect to get financial results, to go in and diligence the business, after the fact. And that costs time from an accounting, legal, and just it moves your eye off the ball of running a successful business and continuing to hit earnings while you're looking backward to try to get money back from an earnout. So again, they're on the rise. To me, it's a bigger signal of the valuation gap that buyers and sellers are currently seeing. Point two, Roger, let's move to page, trying to be mindful of our time here. Let's move to page 41. The second part, so the financial piece in the front, purchase price adjustments, earnouts, those are big in valuation, right? Those are meaningful gaps that we see anywhere from 2% to 20% of the overall deal value falling in. The second is reps and warranties, right? This is how a buyer protects itself, right? The sellers are going to make a handful of statements about its business that ultimately could turn into liability if at the point of closing and before those reps and warranties prove not true. The biggest fundamental question here that dictates the scope of coverage in the reps and warranties that are given by a seller is the use of rep and warranty insurance. For those of you who are not aware of that product, this is a very robust concept that's happened for about 15 or so years now, where the unknown business risk in a transaction is historically moved from the sellers and an escrow or earnouts or other forms of security to a third-party insurance company. The insurance company comes and underwrites the transaction. They review all of the underlying material just as if they are the buyer. They have conversations with the buyer and its advisors to understand the scope of the risk, and then issue a policy, often at signing, alleviating the former sellers from any risk and putting that all onto insurance. Any transaction that we're working on above 20 million and even below sometimes, because we're seeing that the bandwidth there expanding its appetite into those transactions to have rep and warranty insurance. And we're seeing that for two large reasons. Number one, there is the bandwidth. There's an appetite for these underwriters to take on and get engaged in these transactions. Number two, the cost has come down substantially. Take from 2021 for a moment, you have very high costs of execution, very high costs of premium. Those have now come down sometimes 60 to 70% from the highs. And so for a fraction of those costs, you can underwrite better coverage that's more expansive for longer periods of time than if you run through any of the next 30 pages here about what the reps and warranties cover. So that's my fundamental biggest red pill, blue pill analogy for the reps and warranties. Because if you're going to go through an insurer, historically, they've been very lenient into the breadth of coverage under those reps. They're not going to let you speed and go 90 miles an hour, through a school zone. They do have sophisticated counsel. But as far as what you can get from a rep and warranty underwriter versus a well-negotiated private deal with its own private insurance, in my experience, I've seen a much broader subset of protection from the rep and warranty market than I do to the private company. Just quick question. When should the insurance company be involved in the process, at LOI or signing? Great question. I think from the sell side, to the extent you have an interest in the target, it's very important to have that as part of the basis of the LOI. I think most buyers are comfortable using rep and warranty insurance. And when you introduce it early on before the ultimate valuation is presented, most buyers are okay adding a handful of bips to their overall model to introduce that protection, right? If you introduce it too late, then I think it's problematic. And I think it creates kind of a retrade if you're turning drafts of the purchase agreement. So I like it almost before the LOI stage. I like it at the bid stage of the sell side. If I'm on the buy side, I try not to introduce it because I still think, possession is 9/10 the law. And if I can have a large piece of escrow money, I have a much better likelihood of going after that. But if it's a competitive process, I will give the same message to a strategic or a financial sponsor and say, we'll get better coverage for a longer period of time. And if you're investing in this management group going forward, you have the ability to not enforce this against the group you're asking to drive revenue. You can take that and offshoot it to insurance and say, keep running the business management team that we just paid millions of dollars for. You're doing great. We're going to go deal with this claim kind of off on the side. One of the big things I think that we're seeing both with rep and warranty and with the private company deal or deals that are not insured is, where do the claims happen, right? You'll see in this deck, there's all this analysis as to, are there Me Too reps? Are there cyber reps? Those are all important, but we can summarize over 70% of claims that we've seen into three buckets. Number one, the financial statements, right? Financial statements often are where the financial wherewithal of the business is presented, and oftentimes carry a multiple with it on top of it. So if you're paying a multiple on top of wrong financial statements, the claim just balloons up. Number two is customers and suppliers. Again, those are revenue based. I've got top 10 customers, I've got top 50 customers, and there's a breach that the number two customer has provided notice that they're no longer being with the business. That is a backdoor financial statements rep that then carries that multiple on it as well, which is also problematic for claims. The third, I think, that is important is compliance with laws, right? We can fit so much into the compliance with laws rep. I think a lot of lawyers get really bogged down and feel comfortable with a security blanket, saying that there are 100 laws that are possibly breached. I need 100 reps detailing each and every certain law that I can breach. We've done claims with clients that cover a vast majority of reps through one or two very basic sentences. So I think those are the three buckets that we see. If you look through this deck, you'll see individual result, language and data. But what I'm trying to tell you is that most of the claims we see, which are still not very many, I think there's more claims historically that we've seen given rep and warranty insurance, because you're going after a third-party insurer of which you've paid money to, as opposed to suing your founders or your former owners. We've had lots of conversations with clients who may not make a claim even though they have it because the business is going well and they don't want to upset the apple cart. That entire conversation is removed if you introduce rep and warranty insurance to a transaction, because then you can keep the eye on the focus on the business while going and enforce the claims. Many of you may be thinking, okay, what's the value of these policies? Do they actually pay out? I'm happy to tell you, yes, they do pay out. Because claims are not as common in transactions, most people purchase these products but never actually have claims. In the claims that we have had, Haynes Boone has a separate department that is nothing but partners who run insurance recovery. And so I have my own experience through them of claims, but we have folks that do nothing but enforce our clients' insurance policies when a claim happens. And I think they'll be the first to tell you that if there is a claim, even on the margins, the companies are listening to you and they're going through processes where they're ultimately paying these out. So that's a good thing, right? You're buying insurance, unloading the business risk of the sellers. If you're representing sellers, they walk away from the transaction. You can tell them you just got $100 million absent fraud, which is a very, very, very high standard. Go buy that yacht, go put the hot tub in, that money is yours. And if you're representing a buyer, if you have a robust policy, that can cover you for 3 to 6 years up to whatever limit you want, that if a problem occurs pre-closing, you can go after that money and add that back into the financial statements of your post-closing business. So I think it's a really great process that has fundamentally changed the scope of reps warranties and how these deals happen over time. Looking at number 3, and again, I'm skipping over a whole host here because there is data for every claim in here about certain reps and whether I think that's important. And like I said, this PDF should be used as a toolkit because some of the nuanced data is just so nuanced that if you ever need it, it's nice to kind of see where the market is on it. But the overall marketplace really is reps, rep and warranty policy or no. And if so, either way, where are the claims coming? And those are the 3 big buckets that we always tell folks to focus on. The third thing I want to talk about, and Roger, we can flip to page 70. No, sorry, I'm skipping one flag here. 61. Conditions to closing, right? So you've got your purchase price locked in, you've got your purchase price accounting and your working capital true ups locked in, you've got rep and warranty or no rep and warranty, you've got everything locked in. There's a staggered closing, the period between signing and closing. Lots of transactions happen simultaneously. So you kind of do all that, you sign and you fund on the same day. But most transactions, certainly over in the lower middle market, kind of upwards of over 100 million, have staggered signing and closing. The biggest thing we focus on as a seller is certainty to closing, especially if that buyer has financing obligations. A lot of times financial sponsors will want to go out and finance the transaction. Sometimes there's a marketing period for transactions that are large enough where the buyer needs to get a syndicate together to fund the transaction. But it's so important as a seller to ensure that your deal, as best you can, is cut at signing. And absent any meteoric catastrophes in the business, you are going to be in a position to call the buyer to the table and obligate them to close. The biggest thing here, I think we do look at is on page 61 here, is the reps and warranties, kind of a continuation of all these statements. And it's very typical to have a seller make the representations at signing and then again at closing. A buyer's going to want to hear you both times say my reps and warranties are true, correct, and complete and accurate as of these points in time. The biggest key question here that both parties focus on is what happens in the 45, 60, 90 days, or worse, if there's antitrust concerns that come into play. What happens if there are breaches of these reps and warranties? Who should bear that risk? And I think as a seller, it is paramount to lock everything down to an MAE standard, right? So thinking about that practically, absent the meteor hitting the business and just decimating everything, Delaware's only found a handful of times where a true MAE, a standard defined, has actually happened. Your deal is locked and loaded at signing. A buyer is going to want to introduce closing risk to the sellers for breaches or changes of these reps and warranties as between signing and closing. And so there's some data in here that I think is important to look at. but it's a really important thing to focus on, especially if there's financing coming. So if the buyer is going to say, I am not ready to pay for this in cash at closing, I need time, the seller is going to need recourses either in a guarantee, either in an equity commitment letter, or a full backstop. We're seeing in some of our more hot deals where there are a lot of interest, buyers coming to the table with a full equity commitment or guarantee up to the purchase price, taking on the debt financing liability to itself post-closing. So if it can't get the debt together and there's been no MAE, you can call the buyer to the table, the closing table, and say you have 3 days notice. You have to close and get this done. Otherwise, we're going to sue you. And the buyer will come to the table, make the payment, and then finance the deal later. So we're seeing that. That's a very common thing, whether that's at the full level, those are the robust transactions that have a lot of interest, or whether it's at some interim level. There's numbers in the deck that you'll see on termination fees and any type of breakup fees. That's a very important component to have, because what you don't want to have is have the buyer with recourse to exit the transaction, leaving the seller on the altar between signing and closing with no further recourse. The last point, and I know we're getting close on time, is indemnification. This used to be the biggest part of my discussion for years, but I think that that's changed given rep and warranty insurance, right? I think if you go to page 75, Roger, we'll talk about a couple of these points, but if the biggest red pill, blue pill discussion I can have in M&A nowadays is if you're using insurance or not. If you're using insurance, there's a very defined market of what that should include, of how much that costs, and what types of limitations there are. You're not fighting about the historic baskets, caps, limitations. Those are all very well defined, and now transfer that discussion historically between buyer and seller with buyer and insurance agent. And when you have 4 to 6 underwriters quoting out a transaction, they play off each other and they will give you the best terms possible. So indemnification, I think, has changed. This is, the deck has a lot of great information on general survival for 12 months, the baskets, the caps. I think that is very important. We won't go through that here because you can flip through those if you're in the movie where you don't have insurance and you've got to rely on the pure market data. But I think the biggest thing that we've seen is this shift dramatically to insurance that provides a longer, more expansive coverage. 2 notes within insurance, which I think are important, is number one, the fraud definition. We've never, I can't believe in my career we're spending so much time negotiating the definition of fraud, because we all think we know what fraud is when you defraud somebody. But come to find out, there's a lot of different ways to define fraud. The biggest one of which is ostrich fraud. We call it like, you put your head in the sand and you're not paying attention to what's going on. Something happens in the business and therefore I didn't know about it. Is that fraud? And I think actually, if you don't define fraud, that could be a problem for your business. And so the reason I bring up fraud is because if you have insurance and the unknown business risk of the deal is unloaded to a third party, then your only recourse back to you is actual fraud. So if you go out and commit actual fraud, which is knowing, which is willful, and forms the basis for the other side to get involved in the transaction, then all bets are off on insurance. It comes right back to you as a seller, and that's a bad day. And so we do spend a lot of time now negotiating and positioning clients with what fraud means, because that is an exception to the insurance, right? All bets are off there. The second point, which you're looking on the screen here, is sandbagging. Sandbagging is this concept that you're a buyer, you've done all this diligence in your business in doing this deal. Surely you know about things that are happening in the business. Is it fair to rely on the contract, or should we be looking in the mind of the buyer and what it knew when an insurance or a claim against the sellers are happening? Contrary to, I think, popular belief, we like to keep it in the 4 corners of the document. So even if you knew the house was on fire at the point of buying the house, if the contract says the house is not on fire and you have indemnification for it, we're not going to go inside the mind of the buyer and what it knows or what it should know. We're going to look at the 4 corners of the agreement. because Delaware has some rogue case law out there, we're including language in there that says, regardless of what the buyer did, we spent all this money on diligence, we're focused specifically on what is in the four corners of the agreement. That's an important piece. So fraud and sandbagging, you'll hear about those terms. I think the PDF has some really nice language in there on that. The last bit, which I won't bore you, I want to save a couple minutes for questions if people have it, is the actual data surrounding a non-rep and warranty insurance transaction. Survivals, baskets, caps. To me, a lot of that depends on your advisors. If you're working with an advisor that's very sophisticated, whether it's investment banking or legal, you'll be well within the scope of these, if not better. If you're not, people like me will naturally try to take advantage of that and push the envelopes of what it is. We're representing our clients, whether it's sell side or buy side, to the best of our abilities, and we will always get outside of that if not left in check. And so I'll leave you guys to that. But that's kind of an overview, I think, of where we're at. The marketplace is still struggling. We're not seeing that robust, activity back. The financial provisions in working capital earnouts can never be overlooked because clients will do transactions. They'll enter into LOIs and execute documents knowing they've got an ace in the hole through the purchase price adjustment, working capital, or the earnout that'll never pay out. And then focusing on reps and warranties and whether you use an insurance policy or not, certainty to closing, right? Speed kills all, time kills all deals. And so as a seller, ensuring that everything is tight to get to the actual closing, and then how you protect the transaction through indemnification. And so I tried to get through 190 pages, but I think for those of you who don't have it, we'll make sure you get it. But this giant PDF should serve as a good desk reference if you're ever in a need. You have a nuance that I didn't cover today.